Welcome. Today we're going to be covering the Supreme Court. Lately, they've been handing out a lot of rulings coming out like hot gunfire, and it's hard to keep up. So I'm going to quickly cover 4 of their decisions so you don't have to look for them. First, we're going to start with the June Medical Services versus Rousseau. Here, the court ruled that a Louisiana state law that placed hospital admission requirements on abortion clinics was unconstitutional. This law was very similar to a Texas law that was deemed unconstitutional in 2016. Now, you might think it's weird that having hospital admission requirements would be deemed unconstitutional. But the reality is that rural abortion clinics sometimes are hundreds of miles away from the closest hospital. So they would not meet the admission requirements. Therefore, conservative lawmakers make these types of laws so rural areas cannot have abortion clinics. And if you want an abortion clinic, you're going to have to spend hundreds of dollars and travel hundreds of miles. And that's why it was deemed unconstitutional. So, good ruling. Moving on. The Little Sisters of the Port St. Peter on Hull Holmby, Pennsylvania. What a name. This case is about contraceptives. Obamacare gave non-profit religious organizations the right to be exempt from the Obamacare mandate on contraceptives, which was that employers had to provide employees contraceptives in their insurance. Now, religious organizations that were for-profit wanted the exemption too, but they couldn't have it. Now, Trump got into power and he signed an executive order saying that the religious for-profit organizations could have that exemption. Do I agree with that? Yes. Do I agree with executive orders being abused like Trump is doing it? No. Now, the court ruled that the Trump administration had the right to place such executive order, and therefore it ruled in favor of June Medical Services. Okay? Now, I like this ruling because I believe in religious freedom. I believe that if a person is religious and truly believes that contraceptives go against all their beliefs, then they should not be forced to give their employees contraceptives. Now, the ruling was good. I liked it. The reason for the ruling, which was Trump's executive order, I think is flawed. Trump, Obama, Bush, they all have been abusing executive orders. They're not supposed to be doing it like this so often. Things like that had to be passed through Congress. Okay? So good ruling, bad reason. Now you might disagree with the Little Sisters of the Poor's beliefs, but check this out.
I would like to say to women who don't see things the way we see them, or men as well, that a move in favor of protecting our religious liberty would also be protecting them, because it could easily be themselves someday with a different issue that's, very dear to their hearts or very deeply held conviction of theirs that would be under assault. And so if we can protect religious liberty in this case for us, someday that could apply to them as well.
You tell them, sister. Can't disagree with that. Moving on. The Bostock v. Clayton County, Georgia case. This one's about LGBT rights. Specifically, it held that the Civil Rights Act of 1964 protects employees from discrimination against gender or sexual orientation. Now, I like the ruling. I agree with it. Employers should not be able to discriminate based on gender or sexual orientation. But the way we got the ruling, I don't agree with. The 5 justices interpreted the 1964 Civil Rights Act to include gender identity and sexual orientation, when it is very clear that the Congress in 1964 did not have that in mind. That was not their intent, right? So I think the court should have ruled for Clayton in this case, and in their opinion, they should have mentioned that Congress should amend the language in the Civil Rights Act and include gender identity and sexual orientation. But it is not a job for the court, and the court cannot be ignoring intent. Intent is very important. Now, for the last case, and the most egregious of all, McGirt v. Oklahoma. This case is incredible. You're not going to believe it. A convicted rapist, convicted in 1997, appealed, claiming that Oklahoma had no jurisdiction to try him because the eastern half of Oklahoma actually belonged to the Creek Nation. Now, he is also a member of the Seminole Nation of Oklahoma, and therefore he claimed that there was absolutely no jurisdiction for Oklahoma to convict him. It's crazy, right? No, the guy won. And now, for purposes of criminal law, the eastern half of Oklahoma is under Indian jurisdiction. This sets a weird precedent. First of all, a lot of people that are incarcerated now may be eligible to be released because there was no jurisdiction to prosecute them. And second, this makes a very interesting precedent for other factors. If it's Indian jurisdiction for criminal law, why isn't it Indian jurisdiction for something else? And maybe you're going to see that, and maybe we're going to see other states going into their Indian treaties and seeing if they were properly abolished or not. And we can see this happening all over the states. This is dangerous. It's a very dangerous precedent. To conclude, the Supreme Court of the United States, in my opinion, should be hearing cases on whether a law is constitutional or not, and sometimes they should be hearing cases on federal question once the appeal got to that level. What I don't think they should be doing is basically passing laws. That is the job of Congress. And if Congress ain't cutting it, you got to vote them out and replace them with someone that will. But the Supreme Court of the United States should not be doing it. What do you think? Am I crazy or are they crazy? Comment down below and don't forget to like and subscribe. Ginger out.